The Center for Legal and Court Technology, CLCT, previously known and still known around the world often as the Courtroom 21 project, is designed to help improve the administration of justice through appropriate technology, with the key word being appropriate. Everyone who's ever wanted to take an axe or a hammer to a computer understands there are limits. So externally, we have designed courts and supplied advice to organizations, including the Administrative Conference of the United States, federal, state courts, overseas courts, design facilities. We are still finishing a project for the Supreme Court of Nigeria, modernizing the court there. And of course, we do both legal and empirical research. And here at the law school, our goal, of course, is to help the law school in every way possible. We not only help teach a number of courses using our own staff for faculty, but additionally, we try to keep the courtroom as what it is, the world's most technologically advanced trial and appellate courtroom, so that our students can use it and can see where we're all going. There are a fair number of different technologies here in the courtroom. The one that's the most obvious is the ability to present what we call evidence, and a teacher would say visual presentation, to anyone within the courtroom. So as a trial lawyer, I can use a computer, a laptop computer, a tablet, or a phone, and I can show images wherever I need to in the courtroom. But at the same time, we are equipped with multiple video conferencing capabilities, so we can have remote judges, remote witnesses, even remote lawyers. And last April, as far as we know, the first time in the world, a remote juror who, for reasons of Americans with Disabilities Act concerns, could not personally come to the courtroom. We have high-definition cameras as a result, and we have a number of different video conferencing systems. We also have a variety of court record systems. That means the ability to capture what happens in the courtroom. So we have digital audio and video, we have voice recognition, we have what is called stenographic real-time, where a court reporter takes down everything that's said, and seconds later it's available in text. We can have remote interpreters, we can have remote court reporters, as I've said, remote witnesses, judges, and lawyers, not yet remote jurors by choice, except for the one ADA example. And also, we are very big on what we call assistive technology. This is the ability to assist those with special needs. So we are equipped, and in the past, we've done an experimental trial with a nearly blind judge, witness who was blind, witness who could not hear, who could not speak, certainly mobility issues. The courtroom is fully equipped with technology for people who have difficulties seeing, moving, and hearing, among other matters. And then, of course, there are the miscellaneous technologies that take place, including particularly the infrastructure that makes all of this work. That is an ongoing issue. It's lovely to be able to come in and have a computer and make it do something. The problem is, what do you have to have in the background to make all that work? And we are probably the most sophisticated mechanism, if you will, or installation of that type in the court world. There certainly should be classrooms that are better than we are. I'm not sure they're there, but they certainly should exist. Our students use the courtroom in a variety of different ways. First, particularly this year, the courtroom is used as a classroom. And then it's up to the faculty as to the degree, if at all, that they're going to use the technology. We have some faculty who are not comfortable with it. We have some who are, of course, comfortable, and some who are very much so. So we have regular classes. Then we have classes such as technology-augmented trial advocacy, which are based on the technology in the courtroom. It's part of the curriculum. They actually have to use it, and they have to show that they are competent in its use. And then, of course, we have CLCT and its normal activities. We have a student staff of 31, rather extraordinary people, and they work in and around the courtroom. Some have a great deal to do with the technology. There are principal technologists. Others work in many other areas, but they have to be familiar with what's here, and they are all to be trained in its basic operation and use. We'll be doing, for instance, a number of high technology trials in the spring. Some of them are the final exam for students, and our big blowout is what we call the laboratory trial, done almost every year. The lab trial is our best attempt to conduct something similar to usually a federal district court trial with a sitting federal judge and a jury and trying out new things. So last April, for instance, we were testing the use of smartphones and tablets for evidence presentation. Jurors using tablets. This year we'll do the same thing because we learned a bit of what went wrong last year. Plus we'll be trying differing ways of using remote interpretation. So the question is asked, what's the difference between a normal academic technology and courtroom technology? There are a number of answers to that, but probably the most accurate is nothing. Good trial lawyers are, in a manner of speaking, good teachers. They wish to persuade judges or jurors to their point of view. To do that, they have to supply information, often, we hope, in a persuasive fashion. And therefore, in theory, they are using the same type of tools that good teachers often wish to use. And good teachers often want to convey their information in the clearest, simplest possible fashion, particularly visually, and they could use the same tools. Having said that, however, it is a bit more complicated. So most courts of what we call record require a verbatim transcript of everything that is said. Classroom teachers might want to have the same thing, might not in some cases. So we have every method of high technology court record known to humanity in the courtroom, including the world's first virtual reality capability as well. Just a few months ago, we participated in creation of a short piece where if you put on your appropriate goggles, you are standing in the midst of a trial. You can move, look around, up and down, hear anything. And that too is potentially a form of instructional technology, but not one customarily used. One of our problems is trying to find what is being done in a K-12 classroom, for instance, that we could use profitably. We actually tried that last April. And of course, we'd love to return the favor, but as a rule, most of, whether it's higher education or K-12 or whatever, never thinks that there might be something in the local courthouse that might be useful to them. We say occasionally that we change the world from here at William & Mary, and we do. There are an amazing number of courtrooms that have technology, either as a direct consequence of what we have done ourselves by designing and assisting, or simply because what we've done has percolated, so to speak, throughout the entire system. We have helped formulate standards, come up with notions, let's phrase it, as to what's good and what's bad, worried about ethics, and tried to figure out how to put a little nudge here and there to try to help evolve toward a more efficient and we hope a more accurate justice system.